The Competition Commission has approached the Constitutional Court for an appeal in the rand manipulation saga. Several banks are accused of conspiring to fix the exchange rate between the local currency and the US dollar. The Constitutional Court is due to hear legal arguments over the next 4 days. For more, we now cross over to our reporter, Mfundo Mabalane.
Thank you very much, Oliver. Again, we're coming from the Constitutional Court live to you today. Court proceedings currently underway. A very significant case today around the rand-dollar exchange manipulation. I'm joined by the Competition Commission's Makgale Mohlala, his head of cartels. Just to perhaps start with the genesis of this case, because good afternoon. Firstly, thank you very much for joining us.
Good afternoon. Thank you.
No, it's a pleasure to have you with us. A very significant case that's now being heard currently inside court. But perhaps let's start with the genesis of this matter, because it's a long-running case. You guys have been investigating for the longest time. You concluded that many of these banks actually were part of anti-competitive conduct. But just for the benefit of those who might need to be reminded of where this case starts from, just remind us of your findings and then the Competition Appeals Court's overturning of the rulings and why exactly you find yourselves here.
Indeed, it's quite a significant case. We have been looking at this case for quite some time. We referred it to the Competent Tribunal in 2017. At the tribunal, the bank challenged that the Commission doesn't have jurisdiction to prosecute them before the tribunal. That challenge, we appealed it to the Competent Appeal Court. In 2020, the Competition Appeal Court sent the matter back to the tribunal, ordering the Commission to file a new referral, which we did, filed a new referral. The banks once again challenged it. In 2023, the tribunal ruled in the Commission's favor that the Commission has jurisdiction to prosecute the banks and that all the banks must file their answer to the complaint referral. The banks once again went to the Competent Appeal Court to challenge the tribunal's decision. In 2023, the Competent Appeal Court ruled against the Commission in the main, dismissing the complaint against 17 banks, which we have now appealed to the Constitutional Court. And today here, we are at the hearing of our appeal against the Competent Appeal Court's decision to dismiss the Commission's referral of the banks that are alleged to have manipulated the rand-dollar currency pair.
You and I are stating that this is a significant case, but just outline for us its significance, because many have spoken about that type of anti-competitive conduct possibly having distorted South Africa's economy for years. Just talk to us why exactly this case would be important that you pursue it all the way to the Apex Court.
Yeah, I mean, the first important point for us is the point of jurisdiction. So the banks are arguing that the Commission doesn't have jurisdiction to prosecute them because they are foreign-based banks. The local banks are arguing that we can't prosecute them because we don't have sufficient evidence. So with jurisdiction, it's very important to understand that this is a currency that is traded internationally. You know, a rand, it's traded internationally. And if traders sitting wherever they are, New York, London, are trading using the rand, and then they manipulate it to the extent that it have an effect in the South African economy. So the competition authorities in South Africa are the only authority to prosecute such conduct. And if you say they don't have jurisdiction, then it means absolutely no one will then prosecute these banks for manipulating the rand, which then means that the rand can be manipulated by anyone without anyone intervening and prosecuting for that. That's why it's so important. But most importantly, it's so important for us because it talks to the jurisdiction, the power of the authority to prosecute international cartels. If this stands that we don't have jurisdiction, anyone can collude on anything that affects the South African economy, and nobody will be able to do anything because the authority that is responsible to stop such kind of behavior would have been ruled that it doesn't have the powers. So we are strongly opposed to that, and we think that with this case, it should be made clear that we have the authority to prosecute behavior that affect the South African economy, or firms that affect the South African economy and its consumers.
So essentially, if the conduct of foreign firms has a direct impact on local markets, most certainly you must have jurisdiction over them. You speak around the admissibility of evidence. I was listening to Advocate Tembeka Ngqokaitobi a bit earlier on, just outlining the elements that you'll be arguing today, 8 points to be particular. And the admissibility of economic evidence is one part that you're going to argue. Just expand on that. What exactly you want to argue around the admissibility of evidence?
Well, I think the arguments are in court.
Yeah.
That's where,
Not to turn you into a legal expert, yes?
that's where they will be argued. But the point is that evidence of coordination, sometimes it's evidence of behavior of firms. If firm A is doing something that is the same as firm B and firm C and firm C in respect of pricing, in other words, they all charge the same price, that raises a question of whether that same price, how do you arrive at the same price, all of you, except having to have discussed this thing together? So in other words, competition dictates that you should be charging different prices as competitors. That's why you're competitors, you're competing. But when you start seeing competitors charging the same price consistently, that suggests that there may be collusion between them. You may not be having the actual agreement, which is very difficult, by the way, to get, but you have evidence of behavior that is the same. I think that's the point that it was being made in court, that it does not necessarily mean that when you do not have the actual agreement in proceedings of this nature, in prosecutions of this nature, it means that you don't have evidence. Evidence of behavior which consistently show the same pattern of charging the same amount of prices, it has been accepted internationally as evidence of collusion.
Mr. Mohlaka, let me not hold you back. I'm sure you want to go and monitor proceedings. Oliver, we'll leave it there for now. As stated, very significant case that's currently underway for the next 4 days. Most certainly, the big question on many citizens is the extent that this level, perhaps, of anti-competitive conduct would have had, as some have argued that it possibly did distort South Africa's economy for a very long time. So most certainly, we'll be giving you the very latest just as soon as the legal counsel has at least wrapped up its arguments for break. We'll be able to interact with some of them and analysts just to find out how the case is going.